Let me tell you about a local school bus driver who made around $500 a month and cared for her disabled husband. A few years ago, her husband went to the hospital and was billed $518. She couldn't pay the bill and was sued by Medical Recovery Services. She didn't show up for court and was ordered to pay $1,170. MRS tried to garnish her wages, but she legally didn't make enough money for that to happen, so she agreed to pay $10 a month. About a year later, the bus driver contacted MRS, asked what the payoff would be, and was told $1,224. She went in, paid the money, and thought the case was closed. But 6 days later, Medical Recovery Services asked for supplemental attorney fees of $843. That included $114 for the receipt and processing of the bus driver's $10 payments. A magistrate judge denied MRS's requests, saying the bus driver had been told what the payoff amount would be, and that she was not informed about the supplemental fees. MRS appealed, but the district court agreed with the magistrate court. However, the Idaho Supreme Court overturned the decision and said under the law, Medical Recovery Services is owed those supplemental attorney fees. So what are these fees? How are they decided? And if you have medical debt, can you avoid them?
It's very expensive to be a judgment debtor.
Ryan Farnsworth is a bankruptcy attorney. Most of his clients have medical debt. And here's the number one thing you should know.
It's really not a great idea to ignore a lawsuit when you're served.
When you go to the doctor, you generally get an explanation of benefits or a bill following the visit. If you don't pay, the medical office may try to collect on the bill for a few months, and then it could be turned over to a collection company like Medical Recovery Services. Collections will try to get the money from the debtor. If they don't respond, they'll likely get sued.
They have 21 days to respond. If they don't file a response, then the complaining party, the plaintiff, can get a judgment on that 22nd day. They go to the court and say they didn't answer, so give us a judgment against them.
That judgment is called default judgment, and it means you're liable for that debt.
It's a final judgment that cannot be appealed.
Michael Satz is a law professor at the University of Idaho and has practiced bankruptcy and consumer finance law in Texas. What percentage of the cases would you say that people in medical debt end up with a default judgment?
Oh, almost all of them. It's got to be something like 90% of them.
Once that happens, you owe the medical debt, attorney fees, and potential interest.
And the collection costs, that can just continue on and really keep going.
The debtor can work out a payment plan, or the debt collection company could garnish up to 25% of the person's disposable income under certain circumstances.
If you're not making that much money, you can't be garnished.
Let's say you make the payments or your wages are garnished. You finally pay off the original debt, interest, and attorney fees. And like the bus driver, you may think the case is closed. But this is where supplemental attorney fees come in. Fees an attorney can ask a judge for on behalf of the time and effort they put into your case since the original fee was set.
If they tell the court they were looking for you for 10 years and spend $1,000 a year, they can have another $10,000 judgment against you.
This is where it appears Medical Recovery Services is drastically different than other medical debt collection companies in Bonneville County. EastIdahoNews.com spent weeks going through cases involving MRS, Bonneville Collections, and Action Collection Services.
We went through hundreds of cases from these different companies, looking for times when they went after supplemental attorney's fees. I only found one case. That doesn't mean there aren't other cases, it's just within a 1 year period, I only found one. Whereas when we searched through Medical Recovery Services cases, found dozens right off the bat.
And in those cases, the supplemental attorney fees MRS requested were almost always more than the fees on the original debt. We pulled 12 random cases and found the average original fee to be $826. The supplemental attorney fees averaged out to nearly $1,300. But on average, MRS was only awarded $804 by a judge. Some judges are blunt in their assessment of MRS. In a 2013 case that went before the Idaho Court of Appeals last year, a woman was charged a fee each time she made a payment on her debt. Caribou County Magistrate Judge David Kress called the process a scheme, very troubling, and stated the case was absurd, inequitable, and a bad example of collection work. I asked MRS attorney Brian Smith about the fees. How do you determine your fees?
I take the time that I spent working on the case, the research that I did, the you submit that to the court, and then the court gets to determine what is a reasonable attorney's fee.
In a follow-up email, Smith wrote, supplemental attorney's fees are necessary. Otherwise, people who have judgments against them could simply engage in evasive behavior designed to make collection of the judgment very difficult and cost prohibitive. Awarding supplemental attorney's fees encourages judgment debtors to cooperate with paying the judgment rather than making it more difficult to collect. As Smith mentioned, he doesn't decide how much he ultimately gets. That's up to a judge. Do you think the general public is aware of these supplemental attorney fees?
Oh, no. The general public's not even aware of the whole court process, right? That's why you have so many default judgments. And frankly, the consumer laws, they are stacked in favor of the creditors.
And
yes.
If things were to change, it's not the attorneys or the judges that are going to change it. It's going to be the legislators.
Yeah, it would have to be legislated.
From a principled standpoint.
And speaking of legislators, one lawmaker serving from eastern Idaho is Brian Zollinger, a medical recovery services attorney. Zollinger and Smith strongly opposed Medicaid expansion, which passed in Idaho last November.
But I couldn't help but wonder, knowing that they were in the medical debt collections business, if that might have some influence on their thinking.
Carrie Scheid and her husband Jerry believe Medicaid expansion will impact medical recovery services because some of the 60,000 low-income Idahoans who can't afford health care as they are caught in the Medicaid gap will now receive it. In a March 12th column, the Scheids wrote in the Post-Register that Representative Zollinger should publicly declare a conflict of interest when discussing Medicaid issues and bills.
The very people that would benefit the most from Medicaid expansion were often the very kind of people that would end up in their lawsuits.
Zollinger did not respond to our requests for comment, but I asked Smith his thoughts. Do you believe that he should declare it?
I have no involvement in that. You'd have to ask someone to that.
Medicaid expansion, how would that impact medical recovery services?
It does not impact medical recovery services, in my opinion.
Could it in the future?
No. So there's people who collect debt, and Medicaid expansion doesn't really affect that at all.
Zollinger and his opposition to Medicaid expansion got the attention of critical care doctor Kenneth Krell. He admits he may have his own conflict of interest, but wants more patients to have affordable health care so they don't end up in collections or lawsuits.
I may get paid more if more patients have Medicaid than if they have no coverage and I can't collect anything. That's absolutely true. But I think that the conflict of interest of making your living recovering bills from patients and thus having an interest in them not having Medicaid coverage is a fairly glaring conflict.
Krell admits this is personal. He realized his office was using medical recovery services and thought he had to be notified if a patient was taken to court. But that's not the case, so he dropped the company.
I was concerned that they did not have the kind of approach to collection that I wanted my patients being subjected to. I suspect that a lot of doctors are not at all aware of how the collection process works through their offices, and thus are not aware of who they use.
Maybe now the doctors will find out. And if you have medical debt, you'll know what to do and what your options are. Now, over the past week, EastIdahoNews.com has received countless emails, messages, and phone calls from people dealing with medical debt. Many are worried about speaking out in fear of being sued. Doctors and lawyers have contacted us asking to remain anonymous, but giving us new leads to look into. We will continue to follow this story, and if you have something you'd like us to investigate, email news@EastIdahoNews.com. I'm Nate Eaton reporting.